Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We are a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a great webinar conducted by the fabulous Bill Porter on what happens to you after I record my lien? How do I get paid? So Bill has more than 30 years of experience in the legal profession. His practice primarily focuses on the legal aspects of the building industry, including litigation of construction claims. So without further ado, I'll introduce Mr. Bill Porter.
Thank you, Ariella. Much appreciated. So we're going to talk about, as Ariella mentioned, what happens after you have your lien. So at this point, you've really gotten the owner's attention. You're in a position to sell his property if you don't get paid. So this is the very best time of the process for you when you have the most leverage. It's the point at which you can get things done without involving an attorney at the beginning. So the very first thing you need to do is you try to settle the case. So you go to the owner, you go to the GC if that's where you are, or a subcontractor, and you say, I want to settle this case. So what are we going to do here? The owner at that point is really putting a lot of pressure on the GC, and they want to get the case settled. They want to get the lien off their property. So if you can get an agreement at that point, that's the best point to do it, because you're not paying the exorbitant attorney fees that you would have to pay if you go all the way to a lawsuit. So after you have your lien, you're going to have 90 days before you're going to have to file a lawsuit. That's your time period to get things done. Although I would say if it looks like you're not going to get paid within the 90 days and it's only 30 days long, there's no need to wait. Go right to your attorney and say, look, I tried to settle this thing, I can't get it settled. Let's say, though, you do have an opportunity to settle the case and someone says, okay, I'll give you a check and then I need you to release the lien. I want to tell you, don't release your lien until after the check clears. Okay, there's other ways you can deal with this. And they'll say, well, how will I know you'll release the lien? What you want to probably do is give them a form of one of our 4 waivers and releases. And there, I assume that Ariella may have them, but they're on our website as well. They're free to use. It's just porterlaw.com. And you just look under forms and you'll find those forms. But anyway, you're going to want to use a conditional waiver and release. There's a conditional waiver and release on final payment. That's probably the one that you want to do, but although there are some for progress payments as well. But you say to the other party, look, I'll give you a conditional waiver and release on final payment. You give me the check. When the check clears, I will give you an unconditional waiver and release on final payment, and I will release the lien. The nice thing about that process is that when you give the conditional and the check comes in, the check clears, then that is enough on the owner's behalf to go to a judge and say, hey, judge, release the lien, I paid them. And then the rest of it is just...
I'm so sorry to interrupt you. If you want to go to the 3rd slide so that people can see your screen.
Sorry.
No problem.
Okay. Thank you very much. So we're on try to settle the dispute if possible, and don't release your lien until after the check clears. And then you can use conditional and unconditional releases on final payment. You're going to give the conditional in exchange for a check, and you're going to give the unconditional release when the check clears the bank. And then, of course, the next category is you're going to want to release the lien if you settle and you're paid. There are other times that you need to release the lien. If you don't file a lawsuit and you don't get paid, the thing is you cannot leave the lien on the property indefinitely. You're going to have to release it because it's a cloud on the title to the property. So you don't want to... I know some people want to say, well, they kind of think that they want to be a thorn in the side of the owner, but that won't work because they will go to court. They'll say to a judge that 90 days have passed and no one has filed a lawsuit, and then the judge will release the lien, and the judge will put a judgment against you as the person who recorded the lien and didn't release it after 90 days. So you either have to release it after 90 days or you're going to have to file a lawsuit. Now, you have 90 days to file your lawsuit, but you're going to want to contact your attorney maybe 60 days out after the lien is recorded, because you're going to have time to get all the the documents to your attorney. He's going to need a copy of your contract, your final invoices, any letters you have going back and forth, or emails about whatever issues are disputed. And they need some time to pull that all together in order to meet the 90-day deadline. I would never get too close to the 90-day deadline, also because something might happen that will cause the deadline to be missed. I always kind of try to get out maybe 85 days out, and I'll file the lawsuit because it might come back for some reason that you don't expect. Okay, and then that's your 90-day deadline. Now, I will tell you it's possible that you could do something that is called a notice of credit. Okay, and this is a document that has to be signed by the owner of the property before a notary and then recorded at the county recorder. Now, this could extend your lawsuit deadline beyond 90 days up until a year after you last finished the work. Now, I wanted to mention this to be somewhat complete, but the fact is that often this is not helpful because the problems that are causing the owner not to pay you usually are not fixed. Unless you have some reason to think it's going to be fixed, it probably won't be fixed. And then in all likelihood, since you gave the notice of credit, other people are getting paid and you're not getting paid because you were courteous and helpful. So I think this is not the time to extend courtesies to the owner. It's time to play hardball and get yourself paid because something's wrong, and you have to be the squeaky wheel that gets the grease. I mean, that's why you put the mechanics lien on there in the first place, to put leverage over the owner and the GC so that you can get paid. So don't give up halfway through with giving a notice of credit. All right, so you can do it, but I wouldn't necessarily suggest it. Okay, now let's say you get everything done with your attorney. Then you kind of turned it over to your attorney. I would say that it's very important to use an attorney who really understands this area of law. One of the things I see a lot of attorneys don't do is that they don't file a notice of pendency of action or record it at the county recorder's office. This is something in California that needs to be done within 20 days after the lawsuit is filed. Now, this is important for the attorney to do, and you should mention it, because what could happen is that the owner could sell the property to someone else, and they could claim that they didn't have notice because there's no notice of pendency of action recorded, and then they could sell the property where you have the lien without your lien being part of that sale. So basically, they cleanse it of the lien, and you don't want that to happen. If there's a notice of pendency, which has been recorded within 20 days after the lawsuit's filed, then whoever buys the property, I mean, it can be sold, but whoever buys the property is going to buy the property with the lien attached. So they're going to be buying your lien. So you maintain all the leverage that you had, and your lawsuit will go forward. Okay, there's going to be documents that your attorney is going to need before filing the lawsuit. And some other documents later, but just to start off, and I'll re-mention quickly the contract, any change orders you have, the final billing, and any documents showing any disputed issues. Usually they're emails, sometimes they're letters, plus of course a copy of your mechanics lien that's recorded. And in addition to the lien, you might have other rights, and you'll have documents for those as well. Those would be, in addition to the mechanics lien, perhaps a stopped payment notice, and perhaps a bond claim. And these are all the kinds of things that Ariella takes care of for you. But there's these three different remedies that you would have of this nature that are like a mechanics lien. And it's the mechanics lien, which allows you to sell the property where the work was performed. It's a stop payment notice that stops dollars from coming from the owner or from a lender and coming to the general contractor. And it's a bond claim that you can make a claim on a payment bond that might be as part of this project in order to pay people who are not paid, like yourself. And those are claims, they all have their own deadlines, but we're talking about liens here. The lien deadline is the quickest one anyway. So if you have stop payment notice and payment bond rights, then you're going to be okay if you use the 90-day mechanics lien lawsuit deadline as your deadline on these other things as well. So those are probably things that are earlier on that you discuss when you're discussing getting your set up for your lien and stop payment notice and payment bond claim from Ariella. Okay, then, okay, now you're in the lawsuit. What will happen is the attorney will file the lawsuit, serve the lawsuit. People will have 30 days to respond. And then in my view, at that point, some really hard discussions need to be made between your attorney and the other attorney to try to get the case settled before the costs get away from you. But if you don't get it settled right away with that, you're going to have a discovery process. And this is kind of painful for most people because it really detracts from you operating your business. But there are things that are going to be sent to you. For example, a document request. They're going to request everything that you have that relates to the project. And that's one of basically 3 or 4 types of discovery on the discovery process. There's going to be requests to admit. And they're going to be basically in the form of questions, and it's going to be, do you admit that change order number 2 is correct? You know, this type of thing. That just saves time later in the case. Then there's going to be interrogatories. There are form interrogatories and special interrogatories. The form ones are kind of a check the box and answer the questions. They're usually pretty brief, but the special interrogatories are specially prepared, and they relate specifically to your case, and they're drafted by the other attorney without relying on forms. And then once all those documents and requests to admit and interrogatories are all done, then there might be some depositions where you'll have to sit in a chair, raise your right hand, and swear to tell the truth, and then be asked questions for hours on end possibly. So all those things are time consuming and painful, and costly. You want to avoid them when you can, but that's the discovery process. You really want to stay away from that, and it goes both ways. So someone is going to dump all this inconvenience on you, and you're going to be doing it to the other side, and it's going to be very expensive, which is why I say, you know, settle things when you can. And in fact, let me revert to the settling part, is that if you have to take a little bit of a discount on what you're owed, you probably should, rather than have to pay all this expense. Sure, you can get your attorney fees and costs if your contract allows it, or if there's a statute that allows it, which is usually prompt payment statutes. That's another subject, but you can look up prompt payment statutes on Google in California and find them, and I think we have quite a bit on our website about it. But anyway, avoid all that and try to get things settled. If you have to compromise, then maybe do it. Okay, then you're either going to go to mediation or arbitration or trial. Mediation is just an attempt to resolve it with a mediator, and it's just a little back and forth, arguing points of law and points of fact, and seeing if the mediator can force you into a decision. And arbitration is like a trial, except it's not in the courtroom. You're in front of an arbitrator, usually in their conference room of their office, and maybe having witnesses go in and out of the room and basically giving testimony much more informally, like you would in court. And then the arbitrator rendered a decision, and that decision gets sent to the court, and then the court will issue a court judgment. So on the process here, we're down to court judgment, and that is a necessary step to take, even if you have an arbitration, because it has to get to court and have a judge sign it to have it be official. So they send that over there, and you get a judgment. Let's say you won. Let's say you won $100,000, let's say. But how do you get the money? So what you have to do after, and the lawyer can jump on this, and you should have them jump on it right away. You need to get an abstract of judgment. That'll be issued by the court if requested. And it's an official document that says this is what the judgment is. It's $100,000. Interest begins on such and such a date and going forward. And by the way, you can renew judgments every 10 years. So they go on and on. Anyway, I get called by people years later, and they say, oh, I owe you on this, and it's the abstract of judgment and the judgment lien, which is you use the abstract of judgment. The lawyer will create a judgment lien on all their assets, and then that gets recorded in the county recorder of any county where there are assets of the person who owes you the money. Once you do all that, they're really on the hook, and you can renew all this every 10 years. Some people have called me after 5 years and said, I got to pay on this. I can't get any credit. I can't get credit cards. I can't get a car loan. I can't get a house loan. My life is getting destroyed. I want to pay you this money. And so you say, okay, well, here's the amount of money plus 10% interest every year. And so you, in that case, you would get the 5 years of interest at 10% a year, which is a nice 50%. And you would get that money, and then you would release the judgment. The attorney could take care of it, and they'd release the judgment lien, etc. You'd have your money, their life could move on, and you get 10% a year. Now, also for contractors, and this is the last main thing I'll discuss real quickly, there's a process. If you get a judgment against a contractor, a person who's licensed on a construction-related situation, then the Contractor State License Board is going to give the party who owes you the money 90 days to pay it. And either they're going to have to pay it in 90 days, or they're going to have to come to some agreement with you on payment, or they're going to have to file bankruptcy. And if they don't do one of those things, then their contractor's license is going to be suspended. And they cannot work on a suspended contractor's license. If they do, they're subject to disgorgement, which is essentially any money they earn while working on a suspended license. For the whole project, they have to return all the money to the party who paid them. Even if they were, even if their license was suspended for only part of the project, they still need to return all the money for the entire project. So that's a really powerful thing. It's called disgorgement, and you can see articles on our website about it. Okay, I think I've gone down my whole schedule there, and let's see what the final slide is. It is questions. And are there any?
So far, we don't have any questions, but a lot of the times people are only owed. So while people are thinking about their own issues and why they signed up for this webinar, a lot of the times people are owed $5,000. And as you expressed, you just want to settle that quickly, but you're not going to get anywhere. We tell customers that yes, if the lien does not have any impact, perhaps best business practice, take them to small claims court, and that certainly would certainly try to help expedite payment as well, instead of hiring an attorney paying for a small amount that's owed.
Yeah, I agree with that entirely, and I have that happen quite a bit. And I would say not just the $5,000 level, which is the amount that I think is a corporation in California that you can get under small claims, but if it's more, even if you're owed like, I don't know, like let's say $7,500, $8,000, and you can bring the small claims action for $5,000, it's probably better to sacrifice the $2,500 or $3,000 in order to get the $5,000 and not have to pay attorney fees going down the line. What usually happens with cases, even the bigger ones, is that they hardly ever get to trial, and then as part of the settlement, each side is going to bear their own fees and costs, which is a bad deal in general, because you're out all that money paying the attorney. So it's hard to deal with as a concept. The best thing that you can do is think of this very early on in the 90-day period between when you record the lien and you have to file a lawsuit. That's why you want to really strive really hard to get things settled in that point before you have to go to an attorney.
And I think the other part that you really expressed during this webinar is our attorney's fees. How do you make sure that you have attorney's fees? What are the best business practices there? So the listeners here can speak, reach out to you if necessary and have those provisions put in their contract.
Absolutely. I do that for people all the time, but it kind of reads like this, is that you put it in your bid document or your contract. A lot of times you have to do a kind of a proposal, and the people will sign it, and then it becomes a contract. But you want to put in there that if a dispute arises, that the prevailing party will be entitled to attorney fees and costs and expert fees and costs, so that you have those covered. And then you may want to put in something for interest, like 1.5% a month. That's about the most you can get. So even if you settle a case, that is a huge point of leverage, because if you're right in the case and there's a danger of you getting your attorney fees and costs, then you have a much better bargaining position. But those are things that should be put into your contract early on, or if it's in your bid, you need to put in there, don't accept this bid unless you accept all these terms. Another good thing to put in there is that your proposal, which may be incorporated into a later contract or subcontract, you want to say that your proposal is going to be incorporated into the contract or subcontract, perhaps as an exhibit, and that the terms of your proposal are going to control and take precedence over any different term in a subsequently executed document, so that whatever happens, whatever's in your proposal is going to control even your attorney fee clause and everything else. But those are
Wonderful.
things I can add in there. Also, some things we've been putting in lately because of increases in prices is price escalation clauses and what we call force majeure clauses, when suddenly you can't work because the government says, oh, we have COVID or you know, something like that, that things beyond your control. And people nowadays are much more readily accepting those types of clauses in contracts because of all the things that have happened with COVID.
Very good. Well, thank you for adding that. Those terms should be in everyone's contracts. Well, I want to, so far there aren't any other questions, but as you could see, our email addresses and phone numbers are there for you. If you, after this webinar, go, goodness gracious, I should have asked this question, feel free to send us an email and we are happy to answer any of your questions. And Bill, you did a wonderful job. Sorry, please go ahead.
Well, if somebody was on the seminar today and they have a question, my phone number is there on the screen on the right, and my email. And if somebody wants to give me a call and I'll just consider it an extension of the seminar if they have a question in the next week or so.
Wonderful. Well, thank you. Thank you so much again. And I wish everyone a sunny day.
Okay, thank you, Ariella. My pleasure.
Thank you. Bye-bye.
Bye-bye, everyone.